Okay, welcome everyone to our third panel today for Washington Arbitration Week, Day 5. It's December 2nd, 2022. And of course, we've saved the best for last. Um, our panel here today is titled Arbitration and Infrastructure, Energy and Construction Projects in the Midst of Climate Change, a very topical topic. Before we get into that and I introduce our moderator, I just wanted to say a few thank yous to the various folks that made Washington Arbitration Week possible. This is the third Washington Arbitration Week. We were able to get 20 some odd panels together this year. A great participation rate from the major law firms in the arbitration field here in Washington, D.C., hosting events like today's event here at Crowell Moring. It goes without saying that you really need a team, you really need a village, so to speak, to raise the child. And our mutual child is Washington Arbitration Week. And I said this at an earlier panel, but really, I think the diversity of programs, the substantive content that we've seen this week, and the quality of the presentations has just been truly phenomenal. And it really is a reflection of Washington as a place of arbitration. We have the arbitrators, we have the council, we have the institutions. ICSID is headquartered here, for instance, and as you know, 70% of investor state arbitration cases run through ICSID. It really is the crown jewel of the Washington arbitration scene. And really, I think Washington Arbitration Week has grown amazingly, and it's just kind of going from success to success. And I think a lot of that is due, of course, to our great advisory board, our supporters, our sponsors, but also to our organizers like Anna and Maria Lucia, and of course my co-founder, Dr. Jose Antonio Rivas of X Strategy, who has provided the administrative support for kind of pulling together all of Washington Arbitration Week. And just to let you know that we do have an active website, and we are recording these sessions because they're all virtual, and they'll be available for people to go back, watch again, and even if you've missed sessions, the other sessions that were on this week will be available, and certainly recommend folks to go do that. So let's get into our panel. Our moderator is my partner here at Crowell Moring, Meghan Buchman. And Meghan is here in Washington, D.C. She focuses her practice on construction contract disputes and other complex commercial issues in both arbitration and litigation. She has served as a lead and co-lead counsel on a number of international arbitrations and mediations involving large infrastructure projects. And in addition to her disputes advocacy work, Meghan regularly counsels clients on contract matters relating to major construction and infrastructure projects, including dispute avoidance and early resolution of disputes. And I really think that says it all, and why Meghan was perfect in helping us to put together this panel today. These are very current issues, very important issues, and really glad to have you here. And Meghan's gonna take it away. Thanks, Meghan.
Thank you, Ian. So as Ian alluded to, the idea for this panel came about in discussions with him and Jose Antonio about how measures that are being planned or that are underway to combat climate change are bringing to energy, transportation, and other infrastructure and construction projects, and how these changes in turn are affecting investments and contracts, and then what for international arbitration. And each of our panelists here today were obvious choices for their extensive experience. Thank you. For their extensive experience and insights on this topic. And so, with really no further ado, I'd like to just introduce them to you in the order in which they'll present. So we have a couple people who are joining us virtually from other countries, and also we have Greg and Pablo here today. So I'll start with Annette Magnuson, who is joining us from Sweden. I think that's where you are today, right, Annette? Annette is the co-founder of Climate Change Council, which is a think and do tank that is dedicated to accelerating climate change solutions through law. And Annette and her colleagues work toward this goal through a mix of advocacy and advisory efforts, speaking, writing, publishing, with the aim of really engaging commercial lawyers in the fight against climate change and in providing climate-related advisory services to companies, organizations, law firms, and also providing services that include analyzing how the climate transition will affect certain businesses and industries. Before co-founding Climate Change Council, Annette was the Secretary General of the Stockholm Chamber of Commerce, the Arbitration Institute of the Stockholm Chamber of Commerce. And under her leadership in 2017, that one's not working either? Okay, okay, good. The SEC initiated the Stockholm Treaty Lab, which was or is a global competition to innovate new international law for the purpose of climate change mitigation and adaptation. I think it's fair to say that Annette has sat in just about every role possible: advocate, arbitrator, administrator, and she brings a wealth of knowledge and insights, and if you'll pardon the pun, energy to today's topic. Next, we'll have Greg Williams, who's sitting next to me. Greg is the head of global disputes at Wiley Rein. And as Greg and I were just talking about earlier today, his practice really sits at the intersection of international arbitration and international litigation, with many of his cases involving parallel or related arbitrations and litigations spanning multiple continents. Greg is also a member of the board of directors for the Osgood Center for International Studies, which is a nonprofit educational organization that offers short-term foreign policy programs and experiential learning opportunities for graduate, college, and high school students from around the world. And some of Greg's recent high-profile cases have involved key players and initiatives in clean energy technology and smart city development. So again, an obvious choice. Next, we'll have Pablo Lopez, who is also with us today in person. He's an executive vice president with Compass Lexicon and is a quantum and economic testifying expert witness in both investment and commercial arbitration proceedings. He has designed and led teams that are in charge of implementing customized valuation models for, I think it's more than 70 assets from a full spectrum of industries located all over the world. And with an emphasis in emerging markets, which again is quite relevant to the discussion we're having today. These have included key valuation models in a number of high profile and high value cases involving expropriation of energy projects in Latin America. And more recently, Pablo's also been involved in commercial arbitrations involving renewables. As a damages expert, Pablo has particular experience in understanding and valuing the environmental risks and responsibilities and technological changes that will impact the value of an asset. And last but certainly not least, Christopher Goncalves is joining us today from Greece, actually, where he is at the LNG summit there. Christopher is the managing director and chair of BRG's energy and climate practice. He provides both business advice to industry and financial sector clients on energy infrastructure and commerce, including LNG, LPGs, natural gas, oil, conventional and renewable energies, and hydrogen. Chris is also a seasoned industry and damages expert who has given evidence in a large number of disputes under the auspices of ICSID, UNCITRAL, the ICC, ICDR, and also UK and US courts. And he speaks and publishes extensively on a host of climate and energy transition issues, including on the thorny issue of causation and causation analysis in investment arbitrations that have arisen as a result of climate change policy and also the energy transition. So as I said, he's joining us today from Greece, where he's just finished speaking on mastering GHG abatement during the time of energy insecurity. And I'm sure that the conference that he was at featured many in-depth discussions about the speed and scale of change in the energy transition and what that means for LNG. And that's also certainly going to be relevant to our topic today. So before I turn the floor over to Annette to start us off, I just wanted to just very briefly highlight a few logistics. Certainly welcome questions. So if you're joining us online, please just post it in the chat, and we may come to some of them during our discussion, but we certainly have left plenty of time to talk and to answer questions then. And if you're in the room, just get my attention and we'll get your question to the floor. And I think, as you all know as well, the organizers have also organized a networking session at the end of today's session. So for those of you online, you'll go into breakout rooms, and for those of us in the room, we'll mingle. And with that, I'll just turn it over to you, Annette. Thanks so much.
Thank you very much, Megan, and hello, everyone. Thank you so much for the opportunity to be joining you virtually today, and for Crowell Moring to hosting this panel of the Washington Arbitration Week. So, as you heard from Megan, we will give an overview of the different issues that could sort of come into play when we talk about disputes in infrastructure, energy, and construction projects. And you have heard that we represent or a wide range of perspectives. So my task here today is sort of set the stage and see what do we mean when we talk about disputes in the infrastructure, energy, and construction projects against the backdrop of climate change, and what will happen in the future, so to speak. And you heard Megan mention measures planned. So my primary focus will just to give a little bit of a helicopter perspective of societal transitions foreseen ahead, hopefully, if we're going to meet the climate change challenge ahead of us. But of course, many of these developments have already been visible to some extent, including in disputes. And I think you will hear more detailed examples from Greg after me on how that plays out in practice. So this transition that we are currently seeing on many markets and in many sectors again, it's a development that we are seeing, but we need to see much more. And I will give you some examples of what this will mean in practice. When we try to understand what the climate change challenge means in practice, there is plenty to draw from. There is no really shortage of reports and experts telling us what to do and why. And I will not go so much into the why here today, but simply refer to the fact that all of the changes that I will talk about for the next 5 or 10 minutes take their starting point in the Paris Agreement and the 1.5-degree target. So in other words, to use the wording of the Paris Agreement, the ambition is to hold the increase in the global average temperature to well below 2 degrees Celsius above pre-industrial levels, but pursue efforts to limit the temperature increases to 1.5 degrees above pre-industrial levels. And as we heard in the recent COP27, of course, one could have a discussion whether or not the 1.5-degree target is alive or not. And there are different views on that, not surprisingly, but I prefer to sort of still believe that we can reach the 1.5-degree target, but of course it will take quite a lot of an effort. And an important milestone for the Paris Agreement is to reach net zero carbon emissions by 2050. And towards that milestone, we need to reduce emissions by 50% in 2030. So that's just a little bit over 7 years to go, which is not much. In particular, if you're talking in an infrastructure and energy project context, that's really not much time at all. But if you're looking a little bit to then what needs to happen in the society transition to reach this target of net zero emissions by 2050, one source to turn to understand this is the IPCC reports, the Intergovernmental Panel on Climate Change. In the last a little bit more over a year, the IPCC 3 working groups have issued their reports. So the working group 1 came in August last year, which is addressing the physical science basis of climate change. And working group 2 came in February this year, climate change impacts, adaptation and vulnerability. And the third working group issued their report in April this year on mitigation and climate change. And that's a lot of reports, that's a lot of science. But if one wants to summarize it, one could say that working group 1 talks about what is causing the problem with climate change. Working group 2 talks about how bad is the problem, and working group 3, how can we fix the problem? And the findings from sort of how bad is the problem, and so when we talk about impacts, adaptation, and vulnerability, there are some important takeaways for the topic that we're talking about here today. Where the IPCC notes that the key infrastructure systems, including sanitation, water, health, transport, communications, and energy, will be increasingly vulnerable if design standards do not account for changing climate conditions. So here, and this is including sort of the physical threat of climate change as well. And also the IPCC points out that to avoid climate risk requires urgent decision-making for the new built environment, but also retrofitting of existing urban design, infrastructure, and land use. So this is another example how infrastructure, energy, and construction projects are really at the center of climate change adaptation and resilience. And of course, the energy transition at large is a very important element to tackle climate change and the challenges it poses on us. We really need to see a very large increase in the energy investment. So this is essential to get back on track for the net zero emissions by 2050 target. And this is visible not least if one consults the International Energy Agency and their annual World Energy Outlook. And this year's World Energy Outlook just came out in October, so that's not long ago. In the scenario as foreseen to reach the net zero by 2050, it is clear that this requires a rapid uptake of electrification of transport, heating, cooling, and industrial production, and really massive efforts to speed up retrofits and spending on new energy efficient buildings. Again, we're talking infrastructure at large here. And annual spending on energy efficiency need to increase and really need to be more than 4 times higher than today. So looking more at numbers, today we're seeing about 1.3 trillion US dollars annually. That's such a big number, it's difficult to say. That's the amount of the annual investments in clean energy. And really to meet the net zero targets by 2050, that needs to rise above 4 trillion US dollars annually. So that's a massive increase in investment. And another element of this transition, which I think is important to keep in mind when we're talking about this bit, is that the transition is very much tech driven and involves the development and deployment of new technologies, new low carbon technologies. We need to see these new technologies deployed at large scale. And also we need to see new investors to really come into the energy sector to support this transition. We know that almost half of the reductions foreseen to meet the net zero targets by 2050 are expected to come from technologies that are currently in the demonstration or prototype phase. So again, we need to see a push here to make this transition happen. And in some industries, the share of emission reductions that will come from technologies under development is even higher than 50%. So that in and of itself is a challenge. And just adding to the challenges, of course, we are facing a complex geopolitical situation currently in the world in many places, which puts energy security at the top of the list. It illustrates the difficulty of balancing short-term needs and long-term goals. And the short-term needs, of course, being prompted by geopolitical conflicts and challenges, and the long-term goals, again, being the ability and the ambition to meet the net zero by 2050 targets, and how this is reflected in government policy. It brings a fairly volatile policy climate here. So what we have in essence is we have in this context, we have a lot of new technology that needs to be put in place. We have that this needs to happen at a fast pace. We have potentially, or I should say, hopefully, a lot of new players coming in to different markets in different industries to contribute to this transition, and also a lot of new policy that is geared towards enhancing this transition. So new technology, fast pace, new players, and new policy. That all plays together, and it will result in a lot of disputes, because these are components that put together equals a very high risk of disputes. That's something we have seen in the past. These are parameters we know from experience will contribute to a high risk of disputes. And this is something that lawyers and counsel need to prepare for, and of course, prepare their clients for. But as I mentioned, as I started speaking, we have already seen a number of these disputes play out in practice. So I think I will end here, and I will hand over to Greg, because I think he will continue and give you some examples how this has played out. So thank you.
Thanks so much, Annette. And thank you, Megan and Ian and everyone who's here today. It's a great honor. So as Annette has explained, a lot needs to happen in a very short period of time. And it presents a myriad of potential types of disputes. My role today here is to highlight some illustrations, some examples of those, to get a feel of what it looks like today and what it might look like in the future. We've already seen a large number of climate change related disputes from both the investor state and the commercial spheres. On the ISDS side, the system is seeking to balance the need for regulatory flexibility and authority to address these serious issues on the one hand, while reasonably protecting investments, including investments in those technologies needed to address climate change on the other. Recent disputes highlight these tensions and the critical role of international arbitration in resolving such disputes. I'm going to start with North America, since that's where we are. And I'll use as a first example the Keystone Pipeline cases by TC Energy and Alberta. At the end of last year, a Canadian energy company, TC Energy, filed a request for arbitration under NAFTA 11, Chapter 11. As you may know, the 20 US-Mexico agreement reserved to file legacy cases for up to 3 years after NAFTA. TC Energy from the United States for canceling Keystone Pipeline. So I have notes to not only to remind me of what I was saying, but to keep it shorter, because we tend to talk too long. So hopefully I'll keep it short. This is the second time that TC Energy has filed a claim over the pipeline, which would carry bitumen oil from Alberta to Texas and Oklahoma. There are long-running environmental objections to the project, including concerns that this type of oil emits a great deal more greenhouse gases than typical oil, among other things. The Obama administration originally refused to issue the permits on the project, in part on environmental grounds, which led to TC Energy's original ICSID claim. When the Trump administration was elected, it reversed that position and through a series of executive orders, issued the permits, and the ICSID proceedings were discontinued. Then when the Biden administration came in and revoked the permits, TC Energy filed the NAFTA claim. In February this year, Alberta, which has over $1 billion stake in TC Energy and has made loans to the company, also filed a NAFTA claim and is represented by quite an outstanding law firm that we may be being hosted by at this very moment. And that case raises fascinating issue of a government as an investor, which is unique, rare if not unique. And it'll be interesting to see how it plays out. A second example also involves a NAFTA case upholding Canada's fracking ban that was very recently publicly announced. There was a company that was seeking, it was seeking or filed a NAFTA claim based on the revocation of a fracking permit. And it was recently announced that a divided NAFTA panel rejected that claim. The award's not yet public, so we don't know the details or the reasoning, but the investor argued that the revocation of the permit by Quebec violated NAFTA's minimum standard of treatment and expropriation. Canada responded that the measures were in the public interest, were non-discriminatory, and didn't significantly deprive or substantially deprive the investor of its investment because it only affected one of the company's multiple licenses. Well, it'll be interesting to read that award when it comes out and see the basis of the tribunal's reasoning. The last North American example are the Koch brothers' claim against Canada for the cancellation of the cap and trade program, in particular Ontario's cap and trade program. In 2020, the Koch brothers initiated a NAFTA claim against Canada arising out of the 2018 cancellation of the cap and trade program by Ontario and alleged failure to compensate the Koch companies for the emissions allowances that they had purchased. The cancellation occurred right after an election of a new party, which had run on a platform that included a promise to revoke the cap and trade program if elected, and I think even imposes potential imprisonment for anyone who tries to engage in cap and trade activities after the cancellation. That's actually the first legacy NAFTA case after the 2020 agreement, so it's interesting in that effect as well. Now, I'm not going to go into as much detail, but as you may know, there's just as much, if not more, energy and climate related ISDS arbitrations in Europe. For example, Netherlands faces a claim based on its ban on coal power plants. And we've all seen the recent exodus from the Energy Charter Treaty, which I think the Slovenian government described it as, quote, an obstacle to responsible climate and energy policy. France, Netherlands, and Spain, in addition to Slovenia, have already left, with many other countries, including Poland and others, either announcing that they are intending to leave or that they're at least considering doing so. Thus, we can already see numerous examples of investor-state disputes related to environmental regulations and other measures taken to combat climate change, only to the coming years. On the commercial side, climate change also lies at the heart of a wide range of disputes, whether because the effects of climate change, the impact of regulation, or more traditional business disputes related to energy, construction, or other projects spawned by the need to address climate change. For example, we're seeing disputes related to potential force majeure events, either due to or due to regulatory changes. We're certainly seeing disputes, as Annette alluded to, arising from attempts to commercialize developing and rapidly changing technologies. I'll give an example of that in a minute. We're seeing fights about valuation and responsibilities in traditional energy projects that may lose their value as countries shift into new power sources. And we're anticipating to see a fair number of disputes involving emissions trading, given the protean sense of those regulatory regimes and the attempt to try to integrate both region and country-specific regimes among companies, I should say. I'm going to quickly discuss a recent case I have that illustrates a commercial dispute in the clean energy space. We represented a company called Fuel Cell Energy, a publicly traded US company, in a series of international arbitration proceedings and related US litigations against a South Korean energy company. I'm going to refer to the client as FCE because the word fuel cell is both for the technology and the company. It gets hard. So FCE is our client. This is all public information because of FCE's filings and the related litigation. So fuel cell technology is a clean energy source. They work like batteries, so unlike batteries, a fuel cell can continue to generate electricity as long as a fuel source is provided, such as natural gas, subject to a degradation curve. It's not quite a brand new technology, but it's only been commercialized relatively recently. Over the last many years, South Korea has strongly supported and promoted fuel cell technology. It's particularly apt for South Korea. South Korea lands at a premium, so having big solar farms are difficult. It's mountainous, so it's not perfect for wind energy. So fuel cell technology has been strongly supported. In a series of agreements, FCE licensed, progressively licensed its technology to POSCO, taking both portions of the technology and the evolutions of the technology and giving greater exclusivity, particularly in Asia, to POSCO. A series of disputes, things went well. Fuel cells are small. You put them in stacks, and the stacks are combined into modules, and you put the modules together to make a power plant. And for a while, POSCO was selling power plants primarily to local quasi-governmental entities that were providing electricity on a commercial basis in South Korea. Then things started to fall apart. Obviously, the parties disagree about why. POSCO would say that there were problems with the technology. Fuel cell, I should say that in these agreements, in return for the exclusivity and rights to FCE's technology, POSCO agreed to use its best efforts to commercialize the technology and to pay royalties on the sales. And so when as time developed, POSCO was worried about the technology and stopped making sales. And ultimately, the two parties couldn't work out their issues, and it resulted in parallel ICC arbitrations in Singapore and London, 3 arbitrations seated in Korea, a Southern District of New York case, and a Delaware Chancery Court bench trial. So there were things going on everywhere. And basically, what happened was Fuel Cell was claiming that POSCO wasn't exercising its best efforts, and POSCO was claiming that the technology was flawed. The cross claims were over $1 billion. Ultimately, the parties were able to reach a solution under which FCE received exclusive rights to its technology back, and POSCO agreed to make substantial purchases of FCE technology to service the existing South Korean power plants. The case illustrates several dynamics we've talked about. South Korea's promotion of fuel cell technology undoubtedly was the basis for the two parties coming together. And that type of regulatory environment and government promotion is what led to the commercial relationship. The case also surely represents an example of a dispute arising from efforts to commercialize, developing, and rapidly changing technologies. It was one of these disputes that had 8 to 10 underlying agreements, each of which for some segment of time, also changing the seat of the arbitrations about midway through without harmonizing it, leading to all those cases that we saw. It also raises interesting points that were not ultimately resolved because the parties were able to resolve their differences. And maybe as a little bit of a teaser for our next two speakers, one in particular is the question of how to calculate damages in circumstances such as these. The but-for world in a field of rapidly developing and changing technology can be particularly tricky. Does the hockey stick growth that both parties anticipated at the beginning of the relationship, is it reasonable? How is it going to play in? Do hiccups in technology constitute fundamental problems or just normal parts of growing pains? These are all issues that we're going to encounter more and more in these types of disputes. I'll leave it there, but I'll just conclude that we should all anticipate that disputes related to climate change and the regulatory and commercial efforts to deal with climate change, whether investor state or commercial, are all going to play a very significant role in most of the people's lives who are in this room and on screen. Thank you.
Thank you. I think that's a great segue to Pablo.
Thank you, Megan. Thank you, Greg. And thank you to the organizer for the invitation. So to me, talking about this issue of climate change, and I was thinking, how can I add value to this panel as an economist? And the reason why this question for me was important is because in many respects, the disputes that arise here are related to changes in the environment, right? Changes in the environment that affect the commitments that were made within parties at a previous point in time. So in that respect, for me as a quantum expert, the problematic of climate change does not necessarily, or at least maybe I have been missing something over these last 20 years, but does not necessarily govern the key aspect of my testimony or the opinion that I'm going to make. But in reality, climate change is just a catalyst that takes different forms, that changes the property rights that were already assigned to the different parties. So given that I had this initial reaction, I say, well, what am I going to talk about? And what I thought is what is useful is to talk a little bit about certain economic analysis tools that help frame the discussion around climate change. And why this is important, because when we talk about climate change, it depends on where you're talking about it. But typically we are here in DC, typically progressive blue state, or not state, but so there is consensus, there is an urgency to fix it. But we need to separate the urgency to fix it from who needs to pay and who is to blame for the problem that we are having. I will not put it in my words because I have Samantha Gross from the Brookings Institute that has said it better than I. And she says, there is plenty of blame to go around, from fossil fuel companies that for years denied the problem to policymakers reluctant to enact the policies needed to force a real change. Overall, it has been easier for everyone to stick with the status quo. The reality is that we have to acknowledge that fossil fuels have been the catalyst of growth for our societies over the last 200 years. And we have all benefited from it, especially in the developed world. So changing and doing away with fossil fuels is a process that necessarily is going to take a lot of time. And there has to be an appetite by the society to pay for it. And we can see examples where society goes back and forth on this issue. Like we have, for instance, this year, with everything that is happening in Europe and the war in Ukraine, we see a resurgence of coal. People like coal again because they are faced with a shortage of natural gas. There is a greater risk affecting them, right? So things are relative, and it's necessary to take a long-term perspective. And we have to admit that not everybody is that evil. And we have to admit that there's going to necessarily be a trade-off between two evils: who pays for this and how much pollution and climate change we are going to accept. So the second problem, and this is related more to my area of expertise, that is economics, is that climate change falls within one of the most complicated economic problems that you can face. This is because there are two factors. So we can characterize climate change as a product of an externality, and an externality that affects what is called a public good. Let me explain what I mean about that, or what actually economic theory says about that. An externality is a byproduct that affects external agents when I do an economic activity. So when I generate electricity, I'm not looking to pollute, right? I'm just burning fossil fuels, trying to make a profit and selling that to the market. The externality is that there is pollutants that are released to the environment, and that affects other agents, not necessarily me. This has more or less been properly addressed in the last few years, or this type of externality in the economic theory, and has been applied to real regulation by controlling the levels of pollution and regulation, what is called in economics assigning property rights. So let's say that the society has a right to clean air. So if you want to pollute, you either have to pay or you need to avoid polluting. So there is this Coase theorem that essentially says that externality can be addressed by properly assigning property rights. The more difficult challenge for me comes in the area of public goods, right? And what I mean by public good is that the benefit of one action that one individual can take to prevent climate change is marginal, but the cost can be pretty significant. And let me put this in the context of us as consumers. Okay, I can decide to buy an electric car or a regular car. I can decide to buy my electricity from the grid or invest in a solar panel system for my home. Let's say that I buy an electric car or put an electric system on my roof. I have to pay for that. And that costs me significant amount of money. Now, what is the benefit of that? Essentially, will that change by itself the level of contaminants around my home? Certainly not, right? Because my contribution to the pollution is minimal. So if all my neighbors continue to burn gas, then there is no purpose in me just paying up for an electric vehicle or for a solar system, because I will receive no benefit and I will suffer all the cost. So this is perhaps the most challenging part of solving climate change issues, is that it's very difficult for the society to internalize the cost of climate mitigating measures. I'm getting certainly the political buy-in to enforce is equally difficult, right? Because the same, if there is, and we can see it here, if there is a regulation that tries to subsidize clean energy or a regulation that supports the replacement of energy sources, then it's virtually the same, because you need to accept to be paying for something whose benefit is very difficult to really measure in yourself. The third problem that we need to address is that when dealing with infrastructure projects, we are dealing with really long-term investments. And this has a prospective and a historical aspect to it. The historical aspect to it has to do with what I said at the beginning. So we have all been benefiting for over 200 years from fossil fuels. Like it or not, our standard of living would have not been possible without fossil fuels. Now, in order to get that energy matrix, we were in need to commit to certain regulatory frameworks, because we needed people to invest millions and millions of dollars to develop the infrastructure that we needed. Now, once these property rights were assigned, is it proper to change it? I'm not the judge. That's a philosophical or legal question, but at the end of the day, that I believe is the main question that we should be asking ourselves when we talk about climate change, instead of demonizing certain agents, just trying to see whether as a society we committed or we actually benefited from a certain structure, and we are entitled to change it, but how to change it has to be a shared responsibility. And a lot of times, and I will make a short comment on this, there is argument about supernormal profits, or the fact that now certain industries right now are getting very high dividends or profits to their investors. And we need to be, that may be true, and but we need to be careful when those type of statements are made, because you can only judge supernormal profits by looking at the onset of the risk allocation of a given contract. And I can give you a very extreme example. Let's say that I tell you, okay, I made 36 times my investment in a day. And I'm complaining because somebody here is saying that they want to limit my gains by 20, to a factor of 20. And I'm really outraged. And you may say, well, you're being greedy. But then I tell you that, in fact, I was playing a game of roulette. So I made 36 times my investment. I got lucky. Is that a supernormal profit or is part of the rules of the game? So the numbers by itself really doesn't tell you the full story if you don't look at the risk allocation and the payoffs that were expected by the parties at the onset of the relationship. The second challenge for long-term investments and regulations is that priorities change and circumstances change along time. And here it's funny because we are talking about climate change and we tend to be looking all the time at fossil fuels and how we regulate that and how that will generate disputes. But there has been a large amount of disputes on the other side of the spectrum. I have participated in many renewables projects in Latin America and in Europe where the rules of the game were changed. And take, for example, the Spanish experience with renewables, right? So in 2007, around between 10 and 15% of the generation capacity in Spain was renewable energy. By 2012, or 2014, it was around 40%, and it has been flat since that. What explained that huge peak is that there was certain regulation promoting it that ended up being very generous, or what was considered very generous, but really skyrocketed the amount of investment in the sector. Now, after that, those regulations were reversed or suspended, the investment remained flat, and we are still with the same 40% of renewable, which, by the way, is very high for the average of the world. But be as it may, it's funny that sometimes it's difficult to foresee what's going on, even on the other side of the spectrum. And if you think about it today, maybe with hindsight 2020 and what's going on in Ukraine and what I say about coal, it may have not been a bad idea to continue over subsidizing the capacity. And today we will have a much cleaner, less fuel dependent or fossil fuel dependent energy matrix in Europe. So this is just a cautionary tale that in long-term investments, we need to be ready for changes in both sides of the spectrum of what we are targeting and react accordingly. To conclude, and I'm running out of time, you were right that we end up talking much more when we are here. So I don't want to bore you too much, but just wanted to talk about a few things that I see in the realm, in particular of treaty arbitration. And I'm going to actually take a little bit from a keynote lecture that was given by Freddie Surgeons a few months ago, actually in this same law firm in another conference. And he said, well, we need to be conscious in the arbitration community of how we are limiting climate change regulation. And Greg, you touched upon this. But one thing that we need to be conscious is that poor countries or less developed countries who need to reassure investors and enter into BIT treaties are today in a position that is much more limited than more developed nations, because nobody asked for a BIT treatment to invest in the Netherlands or even in the US. Some treaty cases exist, but everybody asked for a BIT protection to invest in Ecuador, Argentina, Venezuela, you call it, or other places in the developing world. So This creates today a much higher cost for these nations to implement changes because they have to abide by VAT protections that other richer nations are not. And this is a problem that compounds the fact that poor countries have not been the biggest beneficiaries so far about the benefits of fossil fuels. So they are asked today to stop their consumption of fossil fuels while the benefit actually was obtained by, in the lion's share, other countries. The last point that I want to touch is that we need to lastly be conscious that, and I will leave this for questions if somebody's interested, but we need to be conscious that there are different ways of tackle the same problem. You can incentivize renewables by subsidizing them, or by taxing fossil fuels, or by having the government investing directly into renewable capacity, or some combination of other tools. So it's important from a policy perspective, particular given these limitations or these regulatory constraints that countries have, to have in mind that there are different tools to achieve the same goal. And then lawyers like everybody almost here can better assist and tell their governments how to better implement these changes without risking or minimizing the risk of running into disputes. Thanks.
Thank you, Pablo. I think with that, we'll turn it over to Chris and then we'll move to questions.
Thank you, Megan. I will cede a lot of my time to questions because I'm going to make just a few brief observations. And I took your point earlier that there might be some insights from my conference here that would be good to discuss. I won't address those too specifically, but I'll touch on a couple of things that might be springboards for further discussion. The first observation, I want to pick up on something that Annette said. She mentioned there was $1 trillion of investment in energy per year, and that it needs to be much more. Fully agree with that, but I think what's interesting also is the evolution of the composition of that investment and the fact that on average, annually, that investment hasn't changed a lot over the last 10 years. Over the last 10 years, investment has gone up or down, perhaps, of course, during the pandemic significantly, but by 10, 20% per year. But it really has kind of hovered around that 1 trillion, 900 billion, 1 trillion kind of mark for quite a while. But it has changed in its composition from being around a decade ago, about 20, 25%, maybe 30% in a given year into renewable energy and what would broadly be called clean energy, forward solutions, and say 70, 75, maybe 80% oil and gas. A decade ago to being now 20 to 30% oil and gas and 70 to 80% renewable energy. So let's just look backwards before we look forwards. What's really going on here? What's driving what? What are the causes for these things? And along with, it should be said, when you're investing $1 trillion per year as a global society, some things are also being retired and phased out. Coal plants are being shut down. Coal plants are being retired early. Some kinds of assets are being, oil and gas production fields are being capped and retired, either at the end of their useful life. So there's always some amount of capacity and energy production coming in and some that's going out, perhaps on an accelerated basis in some cases. The drivers and some of the factors can be policy, of course, regulation, economics, market factors, ESG, capital discipline, etc. And if your view of what's happening or what has happened may depend a lot on where you sit. Just speaking of conferences, I've spent a fair amount of time this week with the oil and gas industry and LNG interests and players. I was recently at a North American Natural Gas Conference in Washington and another renewable energy conference with the American Council on Renewable Energy in Washington. And it is really fascinating, the different perspectives that people have on what the causes are. Not talking about litigation or arbitration here, just talking about commercial and business understanding of the way the world works and what's driving change. I've heard things referenced, for example, that it's, quote unquote, woke ESG, that is shifting capital from one sector to another, that these restrictions on banks and lenders need to change. There's a perspective in some quarters, not all quarters of the oil and gas industry, that there's something of a zero-sum game shaping up. In other words, when renewable energy and clean energy wins, well, that's, they're eating my lunch and we're competing for the same capital. We're competing for the same market, and there's a finite amount of investment. And so if they win, I lose, and so forth. And I thought Annette made the excellent point that really what needs to happen going forward is that investment needs to be not 1 trillion a year, but 2, 3, 4 trillion a year to achieve climate ambitions and targets. And so that raises the question, whatever the causes were in the past, which are clearly complex and multifaceted. And I wouldn't go so far, obviously I'm ducking the issue to say what the prime mover is, because I wouldn't dare, in the sense that I've learned in my career that energy economics and energy drivers are all local and are all specific. It would be wrong for anyone, I think, to say that the same thing that causes one investment to work in China or Southeast Asia would be the exact same thing that causes it to work in Brazil or Mexico or Western Europe. There's different regulations, different policies, different market economics, different positions in the supply chain, proximity to supply, proximity to market, so many factors. You really have to look case by case, asset by asset, project by project, when you get into the tricky issues of causation. But looking forward, so if you imagine, I want to connect two ideas. One, that we need to, as a global society, invest 3-4 times more than we are now. And also that I've been saying, and I've heard other people saying, this huge disconnect between our current state and our global ambition, or our climate change ambition. I think this is now very well known. We talk about it every time there's a COP summit or some sort of, global statements and policy direction, that we know the ambition and the targets, but we really don't have a very good plan to get from here to there. What I said in the conference here this week is that what the energy transition needs is a commercial strategy and tactics to pragmatically make the steps. And this, when I say this, I'm talking about policy, I'm talking about corporate strategy, I'm talking about investment priorities and portfolio target setting and so forth. But there's really this huge gap in between where we are and what the ambition is. What's the solution to that? Well, if we are going to solve it at all, it's going to be a whole new suite of policies, regulations. Pablo just referred to several of the different options for those, but also capital priorities, lending priorities, investment priorities, corporate priorities, and so forth. And it's a complex mix of things that will be creating greater levels of investment and change. And that brings us to, and one of the reasons for the need of that, one of the reasons we're not getting there fast enough, is because what capital likes is security, predictability, and certainty. People don't invest to hit targets 20 years in the future. They invest because they believe there's a path to get there that will be profitable. And so that is, I think, a statement that we're going to need change in policies, regulations, corporate strategies, and so forth, and clear pragmatic paths to get from point A to point B that's going to change this calculus of what is causation when you deal with what happens to a specific asset. I'm talking now, of course, about what happens in a dispute. What cause and effect were in the past are potentially quite different from what they're going to be in the future, if we do, in fact, come up with these pragmatic strategies to get from here to those ambitious targets that we've all been setting. And it's going to raise, in my mind, in a lot of these disputes, whether they're investment disputes or commercial disputes between counterparties, not only these issues of causation, but also huge questions about what is or was foreseeable and reasonably expected between parties when the ambition is known now, but the tactics to getting there were not. And those tactics might be actually the cause of alleged harm or significant asset impairment or the success of one source of energy versus another, etc. Just one final thought before finishing. Regarding the issue of externalities, I was interested in that discussion. One of the things we talked about this week here with respect to methane mitigation and GHG mitigation along the gas and LNG supply chain was our view and the view of some other people that what have been considered externalities, in other words, carbon prices, carbon taxes, we all know now the methane fees in North America, could become increasingly over the course of the coming years and decades internalized in the trade of gas and LNG. When I say that, what I mean is that the price of carbon or the tax on carbon could become second only to the actual price of the commodity and or its commercial flexibility, which are the two things that people mostly compete on and trade on or sign contracts in relation to. Now, it's already happening that these measurements, monitoring, verification are being written into long-term contracts for gas and LNG and are being factored into at least exploratory early day cargoes and cargo pricing, this concept of clean LNG, responsibly sourced gas, certified clean, hydrocarbon supply, such that the industry, I think, is one of its tactics or commercial strategies for internalizing these things within the value chain of gas and LNG trade is to essentially internalize the price and value of GHG mitigation into the actual contracting and trade of the product. So I think that's also quite interesting because it means that, well, all those issues of causation and foreseeability and issues of value that will come up in contracts and commercial counterparty discussions are already starting to happen literally as we speak. So I'll stop there and look forward to the discussion.
I don't know if there's any questions from anybody in the room here. Stacy has the microphone. If so, as she's going around the room, I did have a question really for all four of you, which is each one of you talked about risk allocation in one way or another. And, at the end of the day, all disputes to me, at least, and especially I'm on the private side of it, the commercial arbitration side of it, they boil down to who held the risk. And I think that picks up on what you were just talking about, Chris, about the foreseeability. Parties can allocate risk when they foresee a risk, but to what extent have they properly allocated the risks? And I wonder, Greg, if you want to just talk a little bit about that, and then we'll go around each of you, because I know each of you have some more to say about that.
Sure, and I'll keep it relatively short. Obviously, the parties have done, but in the absence of that, and lawyers come in at the time where there's at least disagreement about the allocation of risks. I'll say that the disputes that have actually ripened, there hasn't been that far-sighted allocation of risk. Typically, more and more we are seeing our clients, and we try to partner with our clients and help them look ahead in addition to represent them when disputes arise. More and more we're seeing our clients starting to think about these issues in a way they haven't in the past. And in the few cases where we have been approached about potential disputes where they've thought about it in advance, we've been able to avoid litigation and arbitration type proceedings. So I think it's getting better, both on a regulatory space, which kind of trumps what the parties do, as well as what the private parties are doing. But it's perfect, and I think it's going to evolve over time.
Pablo?
No, just a brief comment. I think that's certainly, as Greg was saying, the key issue, and it's usually specific to each of the contracts. What I can say is that also in my experience, I have not seen too many cases. I'm trying to think if I can think of anything that where who borne the risk of an environmental event was a key issue. Maybe what I've seen is, in a prospective basis, is, for instance, cases, one case in which a technical expert was asked about the definition of a 100-year storm in a construction project. And I think that the fluidity in this concept, so maybe 20 years ago, it was more difficult argument to make what a 100-year storm meant. Now it's really fluid, because what was a 100-year event a decade ago, maybe it's now every 50 or 20 years. So in that respect, I can see some litigation showing up in that way. But I think that from an economic standpoint, when the definition, let's say, of a 100-year storm that is in the contract is contemporaneous, or has to be contemporaneous to the time of the contract. So I think in that respect, that has precluded some of the cases from popping up, even though there is this fluidity in the allocation of risk.
Annette, maybe we can hear from you next.
So yeah, thank you. So, and thank you to all of the other speakers. Super interesting. The thing that comes to my mind is when we talk about risks in this context is the investor state cases. We have had reason here at Climate Change Council to look a little bit more deeply into that. And we, in our work with the Energy Charter Treaty last year and the study for that purpose. And I think there you have sort of the regulatory risk, and how should you, who bears the burden for that risk, so to speak. And I think maybe going forward, it will be interesting to see how the risk of regulatory change as motivated by, for example, the fact that the government is now seeking to, as you have the example with the Netherlands, phase out fossil fuel. And one could argue there, as a consequence of them being a signatory to, for example, the Paris Agreement, and which is, of course, a fact that has been known for quite some time. And if you would go back even further, you could go back to the to the Rio Convention, the UNFCCC, the Climate Convention. That's even further back, which is quite well known that this is an international convention that is binding on the states and with clear ambitions, although not as clear as the Paris Agreement. But again, it's addressing the climate change situation, and one could argue that there will be regulatory changes as motivated by the UNFCCC. I mean, many of the renewable energy cases we have seen there, the policy was motivated by the UNFCCC and the Kyoto Protocol, at least as described in the facts of these cases. So where should one then put the burden of understanding how this translates into a regulatory risk? We have not seen that yet, to my knowledge, in any case, how these different legal regimes are being balanced and how that plays out in an actual dispute. But I think that will be very interesting to see. And of course, then you would have elements like a due diligence and foreseeability, and how you balance that against legitimate expectations in the investment protection catalog. But I think the issue then of who bears the risk. And of course, putting aside the specifics of the facts of the case, whatever specifics undertakings the government may have given to an investor, for example, putting that aside, just looking at sort of the principle issues in that type of situation, I think I'm hoping we will see something to that play out or get more details on that going forward, because I think it will be important. And it will be important also for understand to what extent, if at all, for example, the Energy Charter Treaty is actually hindering the energy transition. This balancing act and the risk allocation in that context.
Thank you. Last words, Chris?
I'll just comment a couple things. I gave a presentation at a GAR live conference in London about stranded assets, and trying to share with the audience of legal practitioners kind of where we see the big concentrations of heavy oil, coal kinds of assets that are at risk of being, in an accelerated transition scenario, at risk of being overrun or phased out more aggressively, and where those issues will be. We got asked very aggressive questions afterwards by some of the trade press. There was a whole line of arguments that came through in the public domain about how investor state, I'm picking up on Annette's point, investor state arbitration is a secret netherworld where investors go to get money, to avoid climate change or to mitigate the effects on them of climate change. I think that narrative is out there. It is alive and well. But I actually, I haven't seen actual climate change specific cases come up very much in international arbitration. When I think of the renewable energy cases we've worked on, or even the oil and gas cases we've worked on, I would say, climate change, energy transition, or policies were around the margin, but I wouldn't say they were front and center, at least not yet. It was something else, a feed-in tariff that was put into place very aggressively and then was phased down because it was overdone, and it was a second wave of activity. It was a policy change. Yes, it was tied into climate policy, but it wasn't specifically climate driven per se. Things like that. But what is interesting to me right now is actually in the US litigations regarding climate change, there is this big argument. I think it's fairly public and well known. Big argument about what the fossil fuel industry and the carbon majors should have known, allegedly, 20, 30 years ago, and what they should have done about it. And so I think this story, these arguments about what is or was foreseeable at various points in time, what should have been expected, and how parties behaved, might be starting more in the litigation world and might then eventually flow over into the arbitration world in terms of these issues of again, foreseeability and responsible practices, and also in commercial arbitration, reasonable expectations of what risks were when the investment, contemporaneously when the investment was made or when the parties signed the contract or whatever the case may be. It's very dynamic. I mean, what that was 20 or 30 years ago, what it is today, and what it'll be 10 years from now it raises a whole very fascinating set of questions. It's a very dynamic situation. I'll stop there.
Well, I say we take this back up with this panel another time. I'd love to reconvene, maybe even next year we can see where we are. I know there is a question to everyone in the chat, but I want to also respect Ian says, no, it's fine to go ahead and ask. Okay, because I was going to say, I know that we're supposed to move into some networking time, but the question is, there have been recent efforts to modernize the Energy Charter Treaty. One of the features of this effort is to give states the option to remove ISDS protection for fossil fuel investors. Can the panelists please comment on the implications of these modernization efforts on the potential for disputes, and how do the recent departures from the ECT impact this?
I think Annette's probably best.
Yeah, I was going to say, I think Annette, that one might be for you first.
So there are many different sort of issues in this question. So I think first, I think the risk for disputes will depend on the actions by states to begin with. So I'm not so sure whether the modernized treaty as it is proposed will affect that. I mean, I'm just thinking out loud here. In practice, we have not seen, I think, Christopher, that's what you were alluding to. We haven't seen so many investor state cases, and certainly not in the ECT work that we have done. We haven't seen cases that are sort of spot on climate change related cases. Although, of course, one could argue that all of the investments in renewable energy fall into that bucket. They are at least indirectly so. And again, yes, the investors were prompted by this. But the so-called phase-out cases, they are the ones that we know that are in the public domain. They are not yet decided. So it remains to be seen how the current language of the ECT is being applied in those cases, and to what extent fossil fuel investors, fossil energy investors, are sort of using the ECT to for their purposes, and whether that's sort of working against the clean energy transition, the ECT is in fact. So whether the modernization is one of the purposes is to ensure that the Energy Charter Treaty is not hindering the clean energy transition, and one of the means of that being then that fossil fuel energy would not be protected under the treaty. Whether that in and of itself will give rise to state action that could give rise to more claims, I think that's a hard prediction to make. Now, the recent departures from the ECT, that brings with it a number of problems. I think one of them is that it will may be difficult for the modernization to be approved at all, given that the EU is a signatory to the ECT in and of itself, and all of the EU member states need to agree to vote for the EU vote, so to speak, to approve the modernization of the new version of the ECT. And so far, they have not been able to do that. And the issue was postponed. Adopting the new text of the modernized ECT was postponed at the most recent Energy Charter conference. It was postponed to the spring. But if the signatories of the ECT cannot all agree and adopt the new language of the treaty, then there will be no modernization of the treaty. So that, I think, is a very that is something to watch for the spring, to see if the EU member states will find a way for a joint vote to enable the EU to vote in a certain way in the modernization process.
Thank you, Annette. I think we have a question here in the room.
Thank you for the lecture. And I have just two questions, one regarding LNG, another for renewables. I will run very quickly. Regarding the LNG, as Mr. Goncalves is in Greece for the LNG summit, so maybe I can ask you if I may. China was the biggest LNG buyer last year, and also the US is the biggest spot supplier to China last year. But this year, things has been changed due to many issues, especially the war. And so the first one is, generally, how do you foresee the future trade, LNG trade between the two biggest emitters? And second, regarding the terms, the GHG terms you mentioned in the new long-term contracts, which is really interesting. So how do you foresee those GHG? I believe in the current long-term contracts between China and the US, they don't have those terms. But how do you foresee those changes can impact the trade, the LNG trade between those two countries? Thank you.
Excellent questions. I've given literally hours of presentations, charts, graphs, and analysis of that. That would probably be better to talk about offline than to try to summarize in a few minutes of comment here. But just very broad strokes. Regarding the issue of the change in trade between the US and China, there are many factors at play. You mentioned one or two of them, but I would also say, zero COVID policy and the deceleration of Chinese consumption of energy, and particularly imports of LNG, has been very material this year. so far. Well, the year's over, as well as other factors related to, China is one of the major importers, like India, that is very price sensitive. And of course, because of the war and the international energy security crisis, and particularly Europe absorbing such enormous volumes of LNG, the price has reached, at some periods of time, reduced level. Well, the trade has achieved some strange patterns, reduced liquidity, and exceptionally high prices. And that's resulted in, people talking about India exiting the market for a number of years, just sitting on the sidelines and waiting for equilibration, and China reducing its purchases. The other thing that has to be said is China's ramping up its import of pipeline gas and LNG from Russia. And that's another, sort of geopolitical factor that is at play when it comes to US-Chinese LNG trade. So there's just many different things going on there. It's hard to give a simple summary. With the other very interesting question about the impact of GHG emissions intensity on the supply chain and incorporation in contracts and how that will affect trade, we've actually done really an enormous amount of analysis on that. I think I'll just leave it as simple as saying it does, in our view, affect trade a lot. It shifts the sources of supply a bit. It shifts the patterns of imports and consumption. So it changes the trade routes a little bit. And depending on what your assumption is regarding the level of taxes, fees, carbon border taxes, or whatever the case may be that become applicable, including, EU ETS or possible carbon prices in Japan, or some sort of, trade penalties, etc., on GHG content at borders and beaches, it can have, an impact measured in dollars per MMBTU instead of cents. And the last thing I'll say is a lot of people in the industry have done the work to figure out that the mitigation itself doesn't cost dollars per MMBTU, it costs cents per MMBTU. And so the opportunity to avoid costs or create premium value, and at a very low cost investment, I mean, the incentives are all there. The commercial opportunities, the technologies are improving and massifying, very rapidly. So we expect this is going to be a very, very big trend, especially with ESG capital discipline and the challenge of getting new long-term contracts signed, getting new investments sanctioned, authorized, loans approved. Having a certified clean cargo is a really, critical thing. Clean cargo, clean contract, better said, really critical thing to debottleneck some of those challenges to long-term contracting, such as for European buyers who don't want to go 15, 20 years in the future on a fossil supply unless it's very clean. And then ultimately on project financing and taking FID.
Well, thank you so much to our panelists, Annette, Greg, Pablo, Chris. Just a fantastic panel today. Really appreciate everybody's participation, and I'm sure that many conversations will continue offline. But thank you again also to Washington Arbitration Week and everybody who organized this.